If you want proof that the 2024 election is like no other before it, with a Republican primary dominated by an ex-president who has centered his candidacy around his legal woes, look no further than what is happening today. This morning, Donald Trump, fresh off a decisive win in the Iowa caucuses, was at a federal courthouse in Manhattan as the defendant in a second defamation trial brought by the writer E. Jean Carroll. And this time, there's no question of whether Trump defamed her. Judge Lewis Kaplan has already ruled that Trump is liable for remarks that he made in 2019, mocking Carroll's claim that he sexually assaulted her in a chance encounter at a department store dressing room in the 1990s. And Trump is not allowed to dispute Carroll's account. The question now is how much a jury should award E. Jean Carroll in damages for those comments. Opening statements are currently underway. We're going to have a live report from the courthouse when the trial wraps from the day. But here's what's happened so far. Donald Trump was in the courtroom alongside his lawyer, Alina Habba, as well as E. Jean Carroll and her attorneys. It was the first time the two were in the same room in decades. The first order of business was jury selection and the complications of a trial with what is perhaps the most famous defendant in the world was immediately clear. NBC News reports Judge Kaplan asked the potential jurors if anyone believed the 2020 presidential election was stolen. Two people in the pool said yes, and Trump turned around to look at them. The judge then asked whether anyone in the jury pool follows Trump on social media. Two said yes. The judge asked the jury pool if Trump is being treated unfairly by the nation's court system, and two potential jurors seemed to indicate that they do agree with that statement. Ultimately, 9 jurors were selected. Attorney Sean Crowley is delivering opening statements for Carroll. NBC News reports this, quote, Crowley said that in 1996, Trump sexually assaulted Carroll in an empty department store. Crowley said that the sexual assault has been proven by a separate trial 25 years after the incident happened. Carroll's attorney recounted that Trump said that he had no idea who she was, accused her of lying to make money, and threatened her. Trump was president at the time, Crowley said. He had the world's biggest megaphone to attack Carroll. He said that every statement from Trump was an outright lie, which he said has already been decided and proven by 9 jurors. And that's where we start today with former top prosecutor at the Department of Justice, Andrew Weissmann. Also with us, First Amendment scholar and senior visiting research fellow with Columbia University, Ronell Anderson-Jones, and MSNBC host and legal analyst, Katie Phang. Welcome to all of you. Thank you for being with us. Katie, let me just start with you. These are complexities in jury selection that I hadn't really thought of with respect to an unrelated trial, the E. Jean Carroll trial. Why did Judge Kaplan ask those jurors those questions? And what, if anything, does anybody do about the answers?
Well, jury selection is an art form in and of itself, Allie, and it's clearly a way to seat fair and impartial jurors of the defendant's peers in order to be able to reach a decision on behalf of the plaintiff. And the reason why those questions are asked, Allie, is because you singularly have a unique, unprecedented, although that adjective is now getting worn out because he's got so many darn cases. But you have a situation where you have a unique defendant. It is Donald Trump, former president of the United States. And that is why it's important to basically screen out those jurors that have predetermined the outcome of his liability. But the funny thing is, as you just explained to the viewers, his liability has already been determined. It's only left for this jury to decide the amount of damages to award E. Jean Carroll. But it doesn't mean that Judge Kaplan has to completely ignore the screening process. It doesn't mean that he has to ignore the fact that you still have to sit fair and impartial jurors. So in the jury selection process, you can strike jurors for cause, that's one thing, or you can take peremptory strikes. For cause challenges when you're doing jury selection is because that juror cannot be fair and impartial. And based upon the answers provided by a prospective juror, that could result in him or her being stricken from a jury. And that is why jury selection, if you ask any trial lawyer, is sometimes more important than the actual presentation of the case itself. You're not going to have one of those spectacular Perry Mason style moments anymore in court. Jury selection is really the critical component of getting a case done, because usually by the time a lawyer gets up for opening statements, a juror has pretty much decided this case.
Andrew, talk to me about what you do about that, because we have as consistent polling shows, we have a huge number of Americans who think, thanks to Donald Trump, that the 2020 election was stolen, that he's being persecuted and prosecuted by both the justice system and his political opponents. What do you do when that starts permeating juries when the trial is not actually on that topic?
Well, as Katie said, that is the process that what happened this morning that Judge Kaplan oversaw, which was to allow the court and the parties to weed out people who cannot be fair and impartial and can't be confident that they could be fair and impartial with respect to the facts. That means that they have to, A, weigh the facts only in terms of what happens in the courtroom, and B, follow the law that is set forth by Judge Kaplan. Here, that will include the finding of liability, so that they are only determining the amount of damages, compensatory damages and punitive damages. And I will say this is, so I think one way to look at this is that we've heard Donald Trump make lies about the election, about E. Jean Carroll outside of the courtroom, but inside the courtroom, lies tend not to work. And the claims of victimhood that happen outside of the courtroom have not been working inside the courtroom. And so, for instance, just this morning, Donald Trump was on Truth Social continuing to make statements that repeat what E. Jean Carroll says was defamatory. And that happened even today. That's reminiscent of exactly what Rudy Giuliani did in his case, where he was being sued for defamation. That might be a fine strategy politically, but in court, I think that those kinds of statements, which have already been brought to the attention of the jurors in this case, are going to backfire in the same way they did when Rudy Giuliani thought it was a good strategy to make these kinds of statements on the first day of his defamation case. So, yes, we worry about it in the political sphere, but in the court of law, as Katie knows, there is a very different thing when you make those kinds of false statements.
Ronell, there's the legal argument in the court. There's the political stuff that Andrew Weissmann was talking about that happens outside the court. But there's also this middle ground that Trump employs, that Rudy Giuliani did to some degree, but that Donald Trump employs, and that is the undermining of the legal system. The idea that it's probably not going to go my way, so I'm going to use my bullhorn to tell everybody how rigged the system is.
Yes, and I think that part of what's going to be very interesting about the next couple of days is that we're really dealing with this new flavor of libel litigation that is trying to figure out how to deal with defendants that seem almost impervious to deterrence. And so we have to figure out how to map our old libel law principles onto these new frameworks that are very different than what we've expected. We know that this defendant hasn't really been strategizing this as a libel law matter, because the sorts of decisions that you would make if you were strategizing this as a libel law matter are not the kinds of things that we are seeing here. You would not, if you were strategizing this as a libel law matter, go on national television to repeat the lie right after a $5 million verdict declaring it to be a lie. And you wouldn't lean in and double down on social media and express your ill will towards the plaintiff. And you wouldn't suggest that you would get on the stand to contest things that had already been decided by a jury. Those are all actually the opposite of the kinds of incentives that we would ordinarily think would happen in a libel case. And what we see these sets of recent defendants, Giuliani and now Trump, really making different kinds of calculations here. They see that they're facing staggering and historically significant potential punitive damages. And rather than trying to staunch those damages, they're sort of leaning into the lie and seem to be making more public-facing strategy decisions about trying to set up a mechanism for weaponizing the ultimate verdict when it happens. These are things that are going to have to be considered in real time by the judge in this case and by these jurors that have just been impaneled and by the lawyers for both sides. We really don't have a great game plan for what to do in libel law in these situations because it doesn't anticipate a defendant who will try to platform the lie in the damages proceeding.